In Vietnam, not every M&A transaction is about price and negotiation. Sometimes, the biggest obstacle is the law itself, specifically, foreign ownership limits. These limits vary by sector and can directly impact whether an investor can acquire a majority stake, control the board, or even participate at all. In this video, we explain how foreign ownership caps work in Vietnam, their legal implications, and what strategies are available to navigate them. Foreign ownership limits are legal caps on how much equity a foreign investor can hold in a Vietnamese company. These limits are imposed by Vietnamese laws, WTO commitments, or international treaties. They can be fixed, like 49% or 51%, or conditional, meaning foreign investors must meet additional criteria such as joint ventures or licensing approvals. Ownership limits exist to protect national interests, preserve control in sensitive sectors, and align with Vietnam's phased market liberalization commitments. They are most common in industries like banking, logistics, advertising, education, media, and telecommunications. Understanding these rules is not only about compliance, it is about deal viability. Ownership restrictions in Vietnam come from several legal sources, including the law on investment, law on enterprises, and Vietnam's commitments under the WTO, as well as international treaties such as the CPTPP and EVFTA. In addition, sector-specific decrees and ministerial circulars define limits for particular industries like banking, logistics, advertising, and telecommunications. In some cases, no official cap is published, but regulators still apply informal thresholds based on licensing practices. Legal counsel must interpret and verify these from all angles before proceeding. In logistics, foreign investors are capped at 51% for domestic road transport services. In advertising, investors must form a joint venture with a locally licensed advertising company, but there is no statutory equity cap. The foreign stake can be up to 99% so long as the joint venture and licensing conditions are met. In education, foreign ownership can reach 100%, subject to location, facilities, and curriculum approvals. In banking, any single foreign shareholder is capped at 20%, and aggregate foreign ownership in a Vietnamese commercial bank is capped at 30%, unless a higher limit is specially approved for restructuring cases. Foreign ownership caps affect how a deal must be structured. If an investor wants 60% in a 49% cap sector, they will need a nominee arrangement or restructure the business into a non-restricted line. Share transfer percentages must align with legal caps, or the Department of Finance will reject the registration. Legal structuring is key, not just the financial model. If a foreign investor exceeds the cap, the deal can be declared invalid. The investor may be forced to divest the excess shares or face penalties. Licenses issued to the target company may be revoked or refused for renewal. Contract enforceability and tax registration may also be impacted. Regulators increasingly monitor these violations, especially after high-profile foreign investment cases. When ownership caps apply, there are legal options. One is to partner with a local Vietnamese shareholder who holds the restricted portion. This must be carefully structured with shareholder agreements, voting arrangements, and board representation clauses. Another option is to invest below the cap and negotiate enhanced control rights, such as reserved matters, veto rights, and management contracts. In some sectors, converting to a service model or asset acquisition may avoid direct equity restrictions. During M&A approval, authorities will review whether the foreign investor complies with ownership caps. If the target company operates in a conditional business line, the buyer must submit evidence of eligibility and sometimes a full legal opinion. Approval may be denied or delayed if ownership limits are not addressed correctly in the application. Early alignment of structure and legal basis is critical. Ownership caps do not only affect closing, they also impact long-term operations. Licenses granted under Vietnamese majority ownership may not be transferable. Renewals may be blocked if the company becomes foreign invested. Certain business activities like import, export rights, real estate use, and publishing licenses are tied to ownership status. Investors must assess how their investment affects operational flexibility. At LTS Law, we help clients identify sector-specific ownership limits, assess structuring options, and design legally compliant strategies. We provide legal opinions to support M&A filings, draft shareholder arrangements, and ensure control mechanisms comply with Vietnamese law. Our goal is to help clients achieve their commercial objectives without breaching regulatory boundaries. Don't let foreign ownership limits stop your deal. Let LTS Law help you navigate legal caps with smart structuring and compliance. Visit lts.com.vn to schedule a consultation. In Vietnam, knowing the limit is the first step. Knowing how to work within it is where we come in.